Hi, welcome to Jurist Jargon. We hope you had a great Thanksgiving holiday, and let's get back into it. Just a reminder that we're not attorneys, and if you need legal help, please seek out an attorney in your local area.
So, Dave, what are we going to be talking about today first on the show?
So, there have been some interesting bills that have been proposed in Virginia. Virginia's kind of at this point where the state has almost overnight turned from a quote-unquote Republican state to a Democrat state. That being that both their local Congress, House, and Senate, as well as the governor, are all Democrats. And the bills they proposed have some very significant effects on your gun rights if you live in Virginia. That would be State Bill 16, 18, and 64. And these bills have significant limitations on the gun-owning rights of people in those states. For example, State Bill 16 basically creates a definition for what is an assault weapon, which is kind of a really amorphous term, so we have to be careful when we look at how they define it. And they define a assault weapon as either a rifle or a shotgun that uses combustion, so all of them, to eject a round, so all of them, and also contains one of the following: either a flash suppressor, a muzzle brake, telescoping stocks, magazines larger than 10 rounds, and in addition any like kind provision. So shotguns, the number of rounds are allowed to have is 7, not 10 though. And I think we want to talk a little bit about kind of how we're defining assault weapon here, and kind of really the implications of what they're saying here.
Right, that's something that and I just have such a problem with the term assault weapon, because a weapon by definition is used to assault somebody, and if I assault somebody with something, I'm using it as a weapon. It's just like my legal mind really hates that term, but here they've provided some definitional framework for it.
Yes, and I think the bigger issue here is kind of how broad the definition for assault weapon is. And the reason this matters is because they significantly limit your ability to own these types of rifles. And basically all modern semi-automatic rifles contain these provisions, right? They contain either a flash suppressor, muzzle brake, telescoping stocks, or magazines above the prescribed amount. And to limit ownership is basically saying the overwhelming majority of all modern semi-automatic rifles and shotguns are going to be limited in their sale, in their ownership.
Right, and like your granddad's rifle, you kind of have that stereotypical picture in your mind. That might not be affected, but I think that there is an incongruity of reality where a lot of people might think like those are the majority of most guns, and then like it's really exceptional to have weapons with these kinds of features, when in reality the vast majority of American guns that are owned can accept a magazine larger than 10 rounds, for example.
Yes. And so there's a larger problem here too that I think is kind of not being talked about, at least by people who are talking about these bills, and that is the like-kind provision. So this provision says that in addition to telescoping stocks and muzzle brakes, if there's anything that's similar or like-kind to that would also activate this limitation in the bill.
Okay, so one example might be even like old school guns, like your grandfather's rifle. If they can accept a stripper clip, very old school kind of a clip to hold multiple bullets, a lot of those can hold more than 10 rounds. So then you kind of get into an issue: is the clip a like kind, as a 10 round clip like in kind to a 10 round magazine?
And so I want to be very clear. These type of weapons are banned from being purchased or sold. And basically you're outlawing the overwhelming majority of, as Will just said, the overwhelming majority of currently available non-handguns. So, the majority of rifles and the majority of shotguns. And the very important thing to recognize is that generally, which I disagree with these types of provisions entirely, but in other states where you've seen similar bills be suggested or even passed, they usually contain a grandfather clause, which basically says, if you owned these types of guns prior to a certain date, you're allowed to keep them. This does not have one of these grandfather clauses. That means that if this bill gets passed and gets put into effect, that all those people owning these types of guns now have weapons that are illegal. This is a de facto confiscation. Because if you maintain these things that you've purchased, you've bought, then you now own them illegally once this bill is effective.
And do we know, is this a civil or criminal penalty? Because there might be some issues constitutionally with imposing an ex post facto law. But there is, some constitutional scholars disagree on whether ex post facto laws, the prohibition applies to civil penalties or not. So if this is punished only by a civil penalty, they could, easily ignore a grandfather clause and have this be upheld.
Yes, well, it has a criminal penalty to purchase, sale, or own one of these weapons, if this bill were to be passed and these weapons banned, would be a Class 6 felony, which means it would be a crime. So that was just the first of 3 bills. Now, that was the most significant, kind of the most important of the 3 bills, but the other ones are no slouch. So the Senate Bill 18 for Virginia, which is a bill, so which means it's not a law yet, is that possession of all firearms, if it would be moved to age 21. So currently, under the current system, you are allowed to possess a handgun at 18 years of age. You're allowed to purchase a handgun at age 21. You're allowed to purchase at 18 a shotgun or other long gun like a rifle, and you're allowed to possess them at any point prior to that. This proposed law would just limit all of those to you can't even own, you can't possess, and you can't purchase a firearm prior to age 21. So you'd have to be able to drink before you're allowed to own a gun. You can drive, you can vote, you can join the military and die for your country, but you're not allowed to own a firearm at home, in Virginia at least, if this passes.
But Joe, I do think there's a certain amount of wisdom in offsetting drinking age and driving age. So that, you kind of learn some responsibility in how to drive. Some European countries do it in reverse. I think there's a wisdom to the offset. I think combining those at this point is might be unwise. We'll see if there's any unforeseen circumstances of that.
And then finally, the Senate Bill 64 out of Virginia sounds good, but I think there's some serious concerns, and and the concern is, it says if someone trains or teaches someone how to use a firearm, knowing that they are going to cause that they are going to cause a civil disturbance, that becomes a felony, as well as training or drilling with firearms that might cause a civil disturbance. So the important part of this is that there are many protests in the United States that involve people open carrying firearms, and whether or not you think that's right or it's even smart to do to carry guns around to protest, the idea that merely doing that peacefully has now become a felony is kind of a front on both the First and Second Amendment rights.
Yeah, and definitely it's often a concern with firearms is having them out publicly, having them outside of the home is typically where people try to look into restrict their use. And, obviously when you get them closer to the public, there might be a greater impetus to want to restrict them or control them. That actually reminds me a lot in that way of this New York City rule. There was a case that actually went up to the Supreme Court because New York City had a rule which prohibited transportation of any firearm legally owned and licensed by a resident of New York City. from transporting it outside of one of the 5 boroughs, including if they were going to like a shooting range outside of the city, or if they had like a second home outside of the 5 boroughs. You couldn't take a gun registered in the city of New York outside of that. And so this was challenged by some Second Amendment interest groups in the state. And when it gets to the Supreme Court, before they hear it, the city of New York decides to repeal the rule. And so the most recent hearing, I think it was yesterday as of this recording, the Supreme Court heard arguments on whether they could even hear this case. Of course, there's a constitutional limitation on Supreme Court jurisdiction. They're only allowed to hear cases and controversies. They can't give, like, speculative opinions or guiding opinions. There needs to be an issue with 2 parties. And so the question here was, can they even still hear this if they repealed the prohibition? There's a lot of issues if they decide right now to drop the case, in my opinion. One is that a lot of time and effort were spent in appealing this up to the Supreme Court. A lot of money was put into just getting it to this point. And if the Supreme Court says they can't hear it, and it hasn't been declared unconstitutional, tomorrow New York City could reinstate the law, and these interest groups, if their Second Amendment rights are being violated, would have that imposition put back into place, and they would have to go back through the court process to get to the Supreme Court again. Another big issue that did come up in arguments also is that people who've already been affected by this law, anyone who's been penalized or punished under it, they have no recourse. They can't get a rehearing on their case or resentencing or any sort of relief based on the fact that the law they were punished under was unconstitutional.
Exactly, because they've already committed the crime while the law was in effect, and there's no remedy for that if this doesn't actually make it through the Supreme Court.
Right now, because the city decided to relieve the restriction, that doesn't mean that people who violated in the past are free. The other issue also is that it was brought up in arguments that, they don't have a complaint anymore, they can do what they want. Well, there's still a lot of restriction issues that were bundled in specifically with this single rule. And this was the main focus of the case, not being able to take the gun outside of the city. But there's still issues like you can't stop on the way to, the idea is if you could take your gun from your house to the shooting range directly and then back. But if you stop to grab a cup of coffee on the way, it's no longer a direct trip under other city regulations. And so that's a violation. And so that might be overly restrictive. That is still in place. And the Supreme Court might not hear that issue because the other one was lit up.
Okay, and so I think we're kind of looking down in the weeds at this point, which, I think is interesting, but let's bring it back up to kind of like a big picture and what are the political concerns on both sides of the aisle here. So the political concerns here are that, one, the left on the court, which consists of Ginsburg and
Sotomayor, Breyer, Kagan. I always forget Kagan.
And they are the primary ones focusing on saying, well, it's already been, it's been changed, there's nothing here. Whereas the right side of the court has been saying, well, there's some merit here. We say sides and leanings because nobody's actually come out and given an opinion, but we know what questions they ask, so we can kind of gauge the interest of the parties. So we see some kind of political considerations because what could happen if this case gets taken up is that the scope of the decision of the Supreme Court could increase drastically. So when we say that the court rules on whether or not you can stop at Starbucks and whether that's overly restrictive, it might turn into a constitutional question of whether or not you have the right to carry a firearm. If it turns into that question, you could very well have a decision that states that we all have the constitutional right to carry. That's kind of been the cat and mouse game that's been occurring with the Supreme Court and carry cases that have been arising the last few years. I know there was a case out of Hawaii that was kind of both parties were deciding whether or not they wanted to appeal the case, because the case went to an en banc, so the appellate court in the Ninth Circuit, which is California, and an en banc panel is a 3-judge panel compared to having the whole appellate court there. And it was determined that Hawaii, who was not giving a man his right to carry, was not giving him a permit, that they said that it was unconstitutional, and Hawaii was acting unfairly by not giving him his permit. So Hawaii was kind of in this position where they had to choose whether or not they wanted to appeal it to the Supreme Court, who, even if the Supreme Court overturned it, the guy who brought the lawsuit in the first place said he would have appealed it to the Supreme Court anyway. Then we end up back there with this kind of whether or not you have a right to carry question, which is kind of why I think the left side of the court currently is trying to avoid this case out of New York making it to the Supreme Court, because they really want to avoid that question, because once it gets decided that you have a constitutional right to carry, it's very hard to change these decisions. There's now precedent.
And quick correction there, I think you misspoke slightly. En banc is what it means when you're heard before the full court. Normally, these courts are held in 3-judge panels. So I think that I might have focused too much on the consequences of not letting this case go forward. And if we're going to be picking horses here, looking at sides, I think that right now I'm fairly confident in saying that I don't think the court is going to hear this case any further. Just because, we have 4 justices who clearly want to leave it as it is, based on the comments that they made at open arguments. And I also think that Chief Justice John Roberts, he's very much an institutionalist. I think that he gives a lot of weight to the kind of traditions and prominence of the court. And I very much believe, just based on historical opinions by Roberts, that this is going to be a situation where he decides not to let the case go forward because of all of the traditional weight of avoiding cases where there's not a case or controversy.
I kind of want this case to be heard. It's really not the best case for the discussion of whether or not people have a constitutional right to carry firearms outside their homes, but I think that case needs to be heard. I think the court, I do think it's ripe to be heard. I think the court's kind of been waffling and kind of being, feigning away from hearing one of these cases, because there's been several that have arisen in the past few years. And I think it's just about time they heard one, and they seem to just be doing everything they can to avoid hearing this type of case, because it would have such an impactful ruling either way.
Right. Yeah, and I think the issue might be ripe to revisit at this point. It's been over a decade since the last major Second Amendment case, and there's still a lot of questions out there about where the lines of these rights lay.
Well, I think we've talked enough about guns for now. So let's talk about something that hopefully everybody can get behind, and that is, whether you love him or hate him, Trump put out a executive bill that I think does a lot of great things, and that is he put out a bill that was requiring more transparency in the costs of healthcare. Basically, right now, it is inordinately difficult for normal people to find out how much your healthcare costs prior to getting your healthcare. I mean, it's easy to tell how much to get your bill, but if I found out I thought I had a broken arm tomorrow, I don't know how much it's going to cost me to get an x-ray. I don't know whether I should go to the one hospital versus the other hospital. Regardless of the level of care, it could cost me vastly different at different places because of the deals they've cut with different insurers or how much they take out of pocket. So Trump has put forward a few an executive order that would require 2 things. First, it would require insurers to provide consumers access to cost estimations for what they'd pay after, cost estimations for what they'd end up having to pay for their medical care. And they'd have to make that available to all members in paper and electronic form. And they'd have to disclose on a public website the negotiated rates for in-network and out-of-network doctors. This is still being finalized, but the executive order puts forward rules where hospitals would be required to make public all hospital standard charges. That those are payer-specific negotiated charges. That's your type of x-rays, your MRIs, your C-sections, stuff that just they're pretty common. Like the hospitals would have to list all of those prices and make it available to consumers.
Right, and as I understand, hospitals are not particularly happy about this potential regulation.
Oh, absolutely not, because they make a lot of money off it. So do insurers, right? Because they can cut deals with each other. That's really not good for the consumer because consumers can't make smart, informed decisions because they have no idea what their healthcare services cost. So why would the hospitals like that? And the article I read popped up from Reuters, and it said the most ridiculous thing. It said that somehow more transparency of costs would make it more difficult for hospitals to make agreements with these insurers, and therefore costs would go up. Which to me is so incorrect and so dumb. I don't know how you got to that conclusion. So basically, you're positing the idea that more competition to get the purchaser's service by the insurers and hospitals will cost the consumer, my cost to go up. I'm sorry, that flies in the face of most economic principles. You know, we by having more available information, we have come closer to a free market. We've allowed people to make more intelligent decisions, and when people have the information to make those decisions on the cost of their healthcare services, they're going to reward people who price them lower. And yes, that will drive down hospital and insurers' profits. They'll still make a profit because it's not a real free market. I mean, that's the whole point. That's the whole point of having different regulations, and the fact that there isn't perfect information is that there's room for different businesses to make money. In a true free market, nobody makes any money. There's no profit. Consumers get utility. Sellers get some utility, but there's no profit.
Right, but it's just... And again, there's the rules of economics, and sometimes the rules of complete free market economics work a bit differently when you have these non-free market systems at play. But the argument that these hospitals seem to be making is completely economically illiterate. Like, I can't even conceive why they believe that would happen. They're not even saying down is up. They're saying that down is blue under the rules of their system.
Exactly, and just to be clear, they are saying that because that they will be forced to make publicly available the information of how much your insurance pays to doctors and how much you would have to pay, and hospitals have to make available how much you're going to pay for their services, at least their standard services, that somehow that will make it more difficult for insurers and hospitals to connect and make agreements on what insurers will pay hospitals for a service in a certain area, and that will eventually lead to higher costs for the consumer.
Now, I was thinking about this, and one concern that I did have is, though I agree that it'll probably improve cost for the consumer, I do kind of... I'm kind of partial to their argument that this raises a First Amendment issue, so far as compelling them to disclose information. I think there might be some merit to that, but overall, first of all, there was a previous attempt at a regulation here that would force them to publish these prices with any advertisements. And, that might have been too far. I don't think this is, relatively.
Just to clarify, the past attempt at regulation, which Trump put through in a different executive order, was to force drug manufacturers to write the wholesale price for the drug they were selling on any ads they had.
Right, and it's some inconsistency. It's a drug manufacturer versus a hospital. But overall, I think that forcing them to include something in an advertisement is a bit different than saying you have to have prices available.
I absolutely think they're entirely different. I think that there are many other places in such places such as the UCC and other places that describe what type of information has to be available to the consumer. Heck, look at the SEC requirements and disclosures. You're telling me that some businesses have to provide more inner workings of how their company works to investors than a consumer does to how much their healthcare costs? I mean, we're basically saying that very similar ideas in different aspects of American law are operating totally differently when they turn on the same principles.
I'm trying to think of an industry where prices are less transparent than they are in healthcare. Like, pretty much anywhere you go, you're going to at least be able to get a quote or an estimate right away that's usually fairly accurate. I think the one time, like in general commerce, where prices aren't just openly published might be liquor menus at restaurants. They don't want you to know the $8 beer from the $5 one, but otherwise, having access to price information is just part of commerce.
Sure, but if I asked at the restaurant how much the beer cost...
they'll be able to tell you. They just go, look, right.
If I asked my doctor, hey, he says he needs to give me an MRI. Well, doc, how much is it going to cost me for an MRI? He's got no idea what my end price I'm going to end up paying is. No, it's ludicrous. I think that everyone can get behind this. I think this is a great step forward for healthcare, for access. I know a lot of people are talking about how, whatever side of the debate you fall down on what type of healthcare this country should have, this is going to lower prices for everyone. So this will be a good.
So we want to talk a little bit about Google and YouTube,
I guess.
So there was a 60 Minutes report that came out recently, and they were interviewing Susan Wojcicki. I looked up how to say her name earlier, and I know that's wrong. But Susan Wojcicki, the CEO of YouTube, was interviewed, and they asked her about the removal of over 300 political ads for Donald Trump from their services. And, she said that they violated their terms, they violated guidelines, and when asked for details or examples of what might be occurring that made these ads violate guidelines, she told the 60 Minutes reporter to look at their transparency report. 60 Minutes, I'll credit them, they do their homework. They went to the reports, and all that they found there is that was a list of the ads that were removed. You could view the ads that had been removed. But all of them were provided the reason of having violated their company policy, which doesn't actually tell you anything about why they were removed. And I think that it's really this kind of censorship, whether it's warranted or not, is an important question legally. Because certain platforms, internet platforms like YouTube, are provided huge legal protections that other companies and similar forms of business are not.
Well, and talk about lack of transparency. We were just talking about it in the medical industry, but to say that we're going to remove a bunch of your ads and then point that says somewhere you violated something, right? And instead of saying, okay, here's the provision that you guys violated, it's clear that you broke the rules. They didn't do that here. And I think that they did that to make it very difficult to combat them. I mean, at this point, if for the ads to get put back up, the purchaser or the ad space would have to then sue YouTube or their parent company to basically say, well, we had an agreement, you breached our contract, I didn't break any rules despite you saying that, now show me which rule I broke so I can combat that in court.
Right, it's not real transparency if you can only find out what actually happened through the discovery process in a lawsuit.
No, and it's basically, it's forcing them to do it. Because eventually, if you don't comply with the discovery process, I can get an order to compel you, and then your business can start being sanctioned.
I suppose it's more fair than, just letting these ads disappear altogether. At least they have a list of what they pulled down. An interesting note, though, is that they did let these ads run long enough to where they didn't have to refund any money spent by the advertiser under their policies, for the most part, which was kind of interesting. But again, I think the biggest issue why this is important, if we want to talk about some of the protections of these internet platforms, we have to look at the Communications Decency Act of 1996. And what that act does is it provides liability for publishers in certain situations. The most common that was going to come up would be libel or other defamation lawsuits. That is where you attack somebody with untrue information that causes them harm. Of course, this is already a really high bar to meet for a publisher. Since New York Times versus Sullivan, in order to hold a newspaper or something accountable for libel, you have to prove that they intended to cause you harm with the lies and that the real harm was caused, which is a much higher standard than existed previously. But a recent amendment to the Act, I believe it was in 2000, created a liability shield for online internet services that publish others' content. And generally the idea there was that even though New York Times versus Sullivan provides a high bar against libel lawsuits, you know, when you're running YouTube, who knows what people are going to be putting up that might actually meet that standard. And they're not actively policing it, they're not actively curating what goes up, so how can they be held responsible for it?
To clarify, we're saying that there's two different levels here, right? You can either be a publisher or you can be a platform. And this is important for more than just this particular case, right?
Right.
With these ads being taken down. This has become a larger problem over the last couple years on, you know, Facebook, YouTube, Twitter, where you're really starting to see these companies crack down on mostly politically on political opponents, and they seem politically motivated in doing so. And we are seeing the curation of a particular point of view politically, which should tell us that we are seeing someone act as a publisher rather than a platform, and we should be under that high bar to show libel of a publisher rather than the extremely high bar of trying to prove that a platform is somehow responsible for what you put on it.
Right, which is just an outright statutory bar. The question is, you know, originally this was passed because how is YouTube supposed to monitor this content? If they have objective, evenly applied standards, they can restrict or remove things that they find to violate it. But the fact is that they've been able to, with surprising precision, there's evidence that they can target certain types of content, which they say violates their rules, and not other content, which technically violates the rules, but they tend to give more leeway to.
So they're discriminating in who they're applying the rules against. They're
and so the question is, if they actually can act with that level of precision through different machine learning techniques and artificial intelligence algorithms, should they be afforded this statutory protection against liability when they can, you know, they can use their platform to create a certain political paradigm? If they couldn't before, which was the foundation for this Section 230, is the statutory shield for internet platforms. If they can't control it with a high degree of precision, then no, I totally get why they shouldn't be held liable for libel, which is always a fun phrase. If they can, I think that the justification for that weakens substantially.
Well, I think it's time for our voir dire section.
Ooh, vocabulary voir dire. What are we going to talk about today?
Today,
I think you had a suggestion.
Today, we're going to talk about res judicata, which is a really fancy way of saying claim preclusion. So, claim preclusion is the idea that if we have litigated a claim in a previous litigation, that in the new or current litigation, I'm not allowed to relitigate issues that arose in that past litigation.
Mm-hmm. Right. The literal translation of res judicata is that a matter was judged. So, like, this matter already went through court.
So, basically, if I had a, let's say I sued Will, that me and my girlfriend were walking in front of his store, right? Will owns a storefront in New York. We're walking down the sidewalk, and Will, you know, was mopping his store. And so me and my girlfriend walk into his store, and he doesn't put any signs up. The floor's wet. We slip. I fall and break my leg.
Sounds like a you problem.
So I go and then sue Will, and I say, hey, Will was negligent. You know, he did not conform to a standard of care by making sure the floor was dry or putting up a sign to tell people it was wet, and he was inviting people into his store. I got in there and I hurt myself. I sued Will for my medical expenses. It was a long road to recovery. It hurt. So my girlfriend then says sometime later, and let's say that in my case against Will was found guilty of being negligent. That's why he had to pay me for my medical costs. Now let's say sometime later, my girlfriend, you know, she went through that healing process with me, helping me get better, and she said, wow, that was a lot of work, that was emotionally draining. And she sues Will for negligent emotional distress. Well, when that case comes around, Will then can't argue that he wasn't negligent in breaking my leg, because he was already determined to be negligent by the past court.
Right. And so that would what they call collaterally stop me from arguing that I wasn't negligent, because that was already decided against me. But one thing that does protect me in res judicata is that she couldn't sue me again for your medical bills, just for her own distress.
Yes, but she could sue you for her distress, the damages that arose from that. But so that's kind of the idea of res judicata. I know it's kind of short and still kind of high level. I guess the only thing I would add to it at this point is to say that the requirements for res judicata are that the parties are the same as in the previous case, that the claims, which can also be defined as a set of facts from which legal liability arises. So that whole the fact that the situation that we're talking about is the same situation pretty much meets that requirement. And then the final requirement of res judicata is that you have a final valid judgment on the merits.
And I would just like to add that it is a fantastic source for punnery, especially when Chicago has a 5K run every year called the Res Judicata. Get it? It's a race, David.
I get it.
Because it's a race. It's a 5K for charity.
All right. If you like the show today, please give us a like and subscribe. You can find us on Spotify, iTunes, follow us on Twitter, see us on YouTube. I hope you guys enjoyed the show. Have a great week. Please leave a comment if you have any questions, or email us at juristjargon@gmail.com.
See you later, everyone.
Bye.